Committee will come to order, a quorum being present without objection. The chair is authorized to declare recess at any time. Pursuant to Committee Rule 2, House Rule 11, Clause 2, the chairman may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. And now recognize the gentlelady from the great state of Florida to lead us in the Pledge of Allegiance.
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
First order of business is ratifying an updated subcommittee roster. Would the clerks please distribute the updated roster? As they do that, I would like to welcome Ms. Ballant to the committee. She is one of our new members elected in 2022. Prior to being elected to represent Vermont here in the House, she served in the Vermont Senate, including as Majority Leader and President Pro Tem. Ms. Ballant, welcome to the committee. We look forward to your contribution to our hearings and debates. I now recognize the ranking member, Mr. Nadler, for any comments he may have.
Thank you, Mr. Chairman. It is my great privilege to welcome Becca Balint to the Judiciary Committee. Although we were greatly disappointed to lose the leadership of Mr. Cicilline, I'm very pleased that Ms. Balint is joining us. She's in her first term representing the state of Vermont and is the first woman and openly LGBTQ person to represent her home state. After teaching middle school for 14 years, she became an activist and was later elected to the state Senate, ultimately serving as president pro tempore. She received her BA from Smith College, her master's in education from Harvard University, and her MA in history from the University of Massachusetts at Amherst. Although she is just in her first term, she has already made an impact, and I know she will make many contributions to our debates. I also want to congratulate the gentleman from California, Mr. Correa, for assuming the ranking member position on the subcommittee on the Administrative State Regulatory Reform and Antitrust, which had become vacant with the departure of Mrs. Cicilline. I look forward to his leadership on that important subcommittee. I thank the chair for yielding, and I yield back.
Gentleman yields back. Ask unanimous consent that the committee approve the appointments and assignments for our subcommittees as shown on the roster. Without objection, the subcommittee roster is approved. Pursuant to notice, I call up H.R. 788, the Stop Settlement Slush Funds Act of 2023 for purpose of a markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 788 to limit
Without objection, the bill will be considered as read and open for an amendment at any point. The chair now recognizes the gentleman from Texas, Mr. Gooden, for an opening statement.
Thank you, Mr. Chairman. H.R. 788, the Stop Settlement Slush Funds Act of 2023, will eliminate the troubling practice of what are known as slush fund settlements. The act generally prohibits the government from entering a settlement agreement that requires payment to a person or entity other than the United States, except for payments that remedy actual harm or pay for services rendered. This was popularized during the Obama administration, and settlement slush funds exist when settlement funds that should be put in the U.S. Treasury are diverted to third-party entities or programs, all while avoiding congressional oversight. In these cases, as part of a settlement, defendants are typically required to make payments to favored or politically friendly third parties. Because these payments are from a defendant to a third party and the money does not flow through the U.S. Treasury, it is hard to track these settlements and the funds involved. These settlements are wrong. They effectively take some of Congress's power over the purse and put it into the hands of agencies. The Trump administration stopped this practice, but the Biden administration has announced that it is resuming it. And frankly, we should have passed this bill during the Trump administration. And I think the Trump administration's stopping of the practice is one of the reasons there was less of an urgency during that Congress to do so. H.R. 788 will keep the government from redirecting settlement payments away from the U.S. Treasury into the hands of third parties. And the Stop Settlement Slush Fund Act of 2023 will improve transparency and accountability. It requires agencies to file an annual report with the CBO that accounts for how settlement funds are handled, and I urge my colleagues to pass this bill. I also have a correcting amendment at the desk.
We'll get to that in just a second, Mr.
Okay.
Gooden. The gentleman yields. The chair now recognizes the ranking member, Mr. Nadler, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 788, the so-called Stop Settlement Slush Funds Act of 2023, would prevent the Justice Department from negotiating settlements to include payments to third parties, primarily nonprofits and community-based organizations, that are best positioned to remedy harms to the public caused by a defendant's violation of federal environmental, health and safety, and financial regulatory laws. Republicans have accused DOJ of using third-party donations and settlements to operate what the majority describes as politically motivated slush funds. An outlandish argument based on the false premise that such settlements are illegitimate, a premise that both the Government Accountability Office and the Congressional Research Service have thoroughly debunked. Yet committee Republicans have spent countless hours and taxpayer dollars over several Congresses chasing the conspiracy theory that the Department of Justice is attempting to fund liberal activist groups and causes through negotiated settlements. This included a multi-year investigation of the settlements DOJ entered into with several big banks following the 2008 financial crisis, whose greedy appetite for mortgage-backed securities led to predatory lending practices that ultimately left millions of homeowners facing foreclosure. The big banks turned a blind eye to these practices while they packaged mortgages that they knew were of questionable value as securities and sold them to individual and institutional investors alike. Although the big banks' illegal conduct led directly to the 2008 financial crisis, it was difficult, if not impossible, for individual borrowers or homeowners to hold them legally accountable for the harms they suffered from the bank's near implosion of the nation's financial system. In response, roughly 1% of the settlement monies in suits brought by the government ultimately went to third-party organizations, specializing in aiding private homeowners in obtaining mortgage relief or other related community services, a perfectly reasonable way to help remedy the harm caused by these large financial institutions' irresponsible behavior. Unsurprisingly, the Republican investigation into these settlements produced not one shred of credible evidence to support their allegations that this represented some sort of improper action, a common result when it comes to the majority's oversight priorities, it seems. Nonetheless, the majority seeks to enact H.R. 788, a bill that purports to address a problem that does not exist, while its proposed solution would create real negative consequences for the American public. This legislation would curtail DOJ's ability to enter settlements with third-party payments that would provide relief for systemic or diffuse harm caused to the public by illegal conduct. Were Congress to pass H.R. 788, it would be a gift to lawbreakers at the expense of families and communities suffering from injuries that cannot be addressed by direct restitution, such as environmental justice harms, or as my previous example illustrated, harms caused by fraudulent lending practices. Over the years, the majority has attempted to paint a constitutional veneer upon this bill and other anti-regulatory measures because they know that their agenda to stifle the regulatory process is unpopular with the American public. While claiming that the executive branch is violating the Constitution may be a unifying message for Republicans, the public appreciates being able to breathe clean air, to drink clean water, and to borrow money or invest in our financial markets with confidence. The American public understands that this is made possible because Congress provided the executive branch a robust set of authorities to enforce the statutory protections it passed. Ultimately, then, the Republicans' beef isn't really with the so-called deep state bureaucrats. That's just a soundbite popular with their MAGA Republican base. In truth, Republicans want to undo the acts of past Congresses who wrote these popular protections into law. Republicans, however, simply do not have the support to overturn them. So instead, here we are again today, wasting the committee's time considering a bill that has spent nearly a decade failing to advance into law. H.R. 788 does not address any legitimate problem, constitutional or otherwise. Instead, it is a thinly veiled attempt to undermine a congressionally mandated regulatory process that Republicans cannot dismantle outright because they know that the American public wants effective enforcement of critical financial, environmental, health, and safety protections. I urge my colleagues to oppose H.R. 788, and I yield back the balance of my time.
Gentleman yields back without objection. All of their opening statements will be included in the record. The chair now recognizes the gentleman from Texas for the purpose of offering an amendment in the nature of a substitute. Clerk will report. Mr. Goodman, you have an amendment at the desk?
Yes, I do. This amendment alters the bill's.
Hang on a second. Clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 788 offered by Mr. Gooden of Texas.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair recognizes the gentleman from Texas to explain the amendment.
Hi, this amendment alters the bill's punctuation and is not intended in any way to alter the purpose of the bill. I yield adoption. Yield back.
Gentleman yields back. Who seeks recognition?
Mr. Chairman.
I do not want that job. Gentleman from New York, the ranking member is recognized.
I have an amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 788 offered by Mr. Nadler. Page 2, line 7, insert after settlement agreement the following, except as provided in.
Then will be considered as read. Point of order being reserved by the gentleman from California. The gentleman from New York is recognized on his amendment.
Thank you, Mr. Chairman. Mr. Chairman, my amendment would exempt from the provisions of this bill settlements related to hazardous air pollutants, which includes greenhouse gases and the enforcement of the Clean Air Act. A few weeks ago, much of the northeastern part of the country, including Washington, D.C., and my district in New York City, was blanketed in toxic smog from Canadian wildfires. Air quality levels plunged to dangerous, and for those with pre-existing lung conditions, potentially life-threatening levels. For millions of Americans who do not live in areas prone to wildfires, this was a wake-up call to the increasing dangers of climate change and perhaps how we have taken clean, breathable air for granted since Congress passed the Clean Air Act in 1970. For the millions of Americans living in California and the West, it was a reminder of the exacerbating effect climate change appears to have had already on seasonal wildfires. Corporate polluters emitting hazardous air pollutants, including greenhouse gases, in violation of the Clean Air Act, are just the kind of diffuse environmental harms to human health that the federal government might have to address in a settlement agreement. My amendment would carve out an exception for just these sorts of cases, and I urge my colleagues to support it. I yield back.
Gentleman yields back. Gentleman from California withdraws his point of order. Gentleman from Texas is recognized.
Thank you, Mr. Chairman. I actually appreciate the amendment, and I agree with much of what the ranking member had to say in his opening statements. The purpose of this bill, though, is to stop the settlements altogether. I would also argue that if we had a Republican president and settlements were being directed to groups that my colleagues on the other side of the aisle did not appreciate, then that would be a problem as well. The whole purpose of this bill is to do away with this process of the Justice Department making decisions about where money should go after victims have been made whole. And so I would oppose this amendment respectfully. Thank you. Yield back.
Gentleman yields back. Who seeks recognition? Question occurs on the amendment. All those in favor say aye. Aye. All those opposed, no. No. In the opinion of the chair, the noes have it.
Mr. Chairman,
Ranking
Mr.
member
Chairman,
requests.
I ask a recorded vote.
Ranking member requests a recorded vote. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Buck? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Bishop? Ms. Sparts? Ms. Sparts votes no. Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes no. Mr. Klein?
How we doing?
Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Mr. Moran? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Bush? Ms. Bush votes aye. Mr. Ivey? Ms. Balint? Ms. Balint votes aye.
Gentleman from Arizona.
Mr. Biggs, you're not recorded. Mr. Biggs votes no.
Clerk will. All members voted. Clerk will report.
Mr. Chairman, there are 8 ayes and 11 noes.
The amendment is not adopted. Who seeks recognition? Question is on the adoption of the question is on the adoption of the amendment in the nature of a substitute. This will be followed by immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
Opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. A reporting quorum being present, the question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
Opinion of the chair, the ayes have it.
Mr. Chairman, I ask for a roll call vote.
Ranking member requesting a roll call vote. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Isa? Mr. Buck? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes yes. Mr. Biggs? Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Bishop? Ms. Bartz? Ms. Bartz votes yes. Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes yes. Mr. Klein? Mr. Gooden? Mr. Gooden votes yes. Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Mr. Moran? Ms. Lee? Ms. Lee votes yes. Mr. Hunt? Mr. Fry? Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Schiff? Mr. Schiff votes no. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Mr. Neguse votes no. Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Escobar votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush? Ms. Bush votes no. Mr. Ivy? Ms. Ballant?
No.
Ms. Ballant votes no.
Gentleman from Arizona.
Mr. Biggs, you're not recorded. Mr. Biggs votes yes.
Gentleman from California.
Mr. Isa votes yes.
Right.
Gentleman from Wisconsin.
Mr. Fitzgerald votes aye.
Gentleman from Florida.
Mr. Gates votes yes.
Gentleman from New Jersey.
Mr. Van Drew votes yes.
Clerk will report.
Mr. Chairman, there are 15.
Young lady from Georgia.
Ms. McBath votes no.
All members voted. One to vote. Clerk will report.
Mr. Chairman, there are 15 ayes and 10 noes.
The legislation is passed. Without objection, the bill will be, the ayes have it, the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, we call up H.R. 3446, the Sunshine for Regulatory Decrees and Settlements Act of 2023 for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the resolution.
H.R. 3446, to impose certain limitations on consent decrees and settlement agreements by
Without objection, the bill will be considered as read and open for amendment at any point. The chair recognizes the gentlelady from Indiana, Ms. Sparks, for an opening statement.
Thank you, Mr. Chairman. H.R. 3446, the Sunshine for Regulatory Decrees and Settlement Act, will hold problematic sue and settle arrangement and related settlement-driven rulemaking. Sue and settle cases occur often when pro-regulated plaintiffs sue willing government agency which agree to settlements and policy changes and that skirt standard rulemaking requirements to reward special interests. This is a problematic approach to government litigation and policy development. When a pro-regulatory plaintiff sues and settles with an agency in ways that require certain types of rulemaking or policy outcomes, the result is the plaintiff and agency can avoid public scrutiny and congressional oversight of the agreed-to policy. Sue and settle tactics also can bind government agency to policies that extend from one administration to the next, which can be inconsistent with congressional intent. H.R. 3446 just fixes this problem. The bill requires federal agency to be transparent in their rulemaking and to act consistent with the requirements of the Administrative Procedures Act. The bill is needed reform that will guard against the misguided tactic in return transparency and congressional oversight to an important category of agency rulemaking and policy formation. I urge my colleagues to support H.R. 3446, and it's also the separation of powers. So I think it's very important that Congress start taking their powers and responsibility back because we represent the people, and judicial branch shouldn't be overstep their authority. So I yield back.
Now recognize the ranking member, Mr. Natter, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 3446, the so-called Sunshine for Regulatory Decrees and Settlements Act of 2023, is yet more old wine in a new bottle, part of the Republicans' long-standing canon of proposals to undermine environmental, health, safety, and consumer protections in the name of defending corporate greed. This legislation would create a gauntlet of unnecessary, burdensome, and time-consuming procedures that would effectively stifle settlements and consent decrees that resolve what can best be described as routine deadline lawsuits. To begin with, the bill is a solution in search of a problem. The issue that arises in the cases covered by this bill is a simple one. A federal agency has failed to meet a statutory rulemaking deadline or other duty, and a private party files a lawsuit demanding that they follow the law. That's it. To justify this deeply problematic bill, the majority likes to spin tales of nefarious motives and collusion with liberal activist groups, a premise that the Nonpartisan and Independent Government Accountability Office debunked years ago. These deadline lawsuits do not result in a particular rule or policy outcome, nor do they circumvent the normal rulemaking process established by Congress under the Administrative Procedure Act. They simply require federal agencies to do the job that Congress gave them. Paradoxically, then, instead of protecting its constitutional prerogatives, H.R. 3446 would thwart Congress's will by further slowing down the rulemaking process that it has mandated. Of course, for my Republican colleagues, it's not a bug in the legislation, but rather its primary feature. Indeed, the rules that agencies issue at Congress's direction to protect Americans from a whole array of risks that confront them in their daily lives, ranging from toxic air and water to defective cars, unsafe workplaces, tainted baby formula, dangerous medications, and financial fraud, are very popular with the public. According to the Coalition for Sensible Safeguards, an overwhelming majority of voters support strong regulation in all of these areas. In short, my Republican colleagues and their corporate allies lack the political support to overturn these protections. So instead, they try to gum up the process by which agencies can protect the public through bills like H.R. 3446. For example, this legislation requires, among other things, that agencies solicit public comments on proposed regulatory consent decrees and settlement agreements before they can be entered into, and respond to each public comment before submitting them to the court. The bill also requires courts to presume, subject to rebuttal, that almost any private third party is entitled to intervene in litigation concerning a regulatory action, and would require that such a third party be permitted to participate in settlement negotiations between the litigants. The effect of these provisions, individually and cumulatively, would be effectively to delay and possibly derail agency efforts to develop and implement congressionally mandated public health, safety, and environmental safeguards in a timely manner. Additionally, the bill would encourage costly and wasteful litigation, a cost that would be borne by American taxpayers. Indeed, the Congressional Budget Office confirmed a decade ago that this bill's substantively identical predecessor would impose millions of dollars in additional costs because of the prolonged litigation and administrative expenses associated with it. Finally, the bill is totally unnecessary. Justice Department guidelines, first issued by Attorney General Edwin Meese 37 years ago, and later codified in the Code of Federal Regulations, already set forth detailed criteria that government attorneys must follow when determining whether to enter into consent decrees and settlement agreements. They are designed to prevent the kind of so-called collusion that the bill's supporters allege, and the GAO confirmed as recently as 2017 that there was no evidence that agencies were failing to comply with these regulations. For all these reasons, a broad coalition of public interest, labor, environmental, and civil rights groups have historically opposed legislation substantively identical to H.R. 3446, including the Natural Resources Defense Council, the American Civil Liberties Union, the NAACP, the Sierra Club, and Earth Justice, among other groups. I join them in opposing this ill-conceived and deeply problematic bill, and I urge my colleagues to oppose it as well. I yield back the balance of my time.
Gentleman yields back. The chair now recognizes the gentlelady from Indiana to offer an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment in the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 3446, offered by Ms. Sparks of Indiana.
Without objection, the amendment will be considered as read. The chair now recognizes the gentlelady from Indiana to explain the amendment.
This amendment is just a simple amendment. It includes a minor alteration to improve the text and reduce possible confusion. It's not intended in any way to alter the important purpose of this bill. So I urge my colleagues to support this amendment, and I yield back.
Gentlelady yields back. Who seeks recognition? Gentleman from Georgia, Mr. Johnson, is recognized.
Thank you, Mr. Chair. The suits at issue here are lawsuits where a plaintiff sues a government agency because the agency missed a statutory deadline to review and revise a rule, or because an agency failed to take statutorily required actions. In these cases, in these kinds of cases, it is very unlikely that the government would win the case, so the agency settles and it agrees to take the action or promulgate the rule that it was already legally obligated to do. And that's just common sense. Moreover, many of the agency's duties concern public health and safety. Congress imposed these duties on agencies and authorized citizen lawsuits to enforce them precisely because we want agencies to pass rules that protect the public welfare and keep us safe. This bill would prevent that. H.R. 3446, the so-called Sunshine Bill, would slow down the rulemaking process by creating a gauntlet of burdensome and time-consuming procedures before allowing an agency to settle. Hypothetically, under this bill, if the regulatory action at issue involved the Clean Air Act, anyone who breathes air or any affected corporation would have a rebuttable right to intervene in a consent decree or settlement agreement. Then, between the bill's forced mediation provision, new notice and comment period for proposed settlements, and other onerous and unnecessary requirements, agency rulemaking would be slowed even further. This bill opens the door wide to dilatory tactics by corporations, and it would force expensive and time-consuming litigation at taxpayer expense. Indeed, the Congressional Budget Office noted that a previous version of H.R. 3446 would impose millions of dollars in additional cost on taxpayers. Furthermore, H.R. 3446 subverts the federal rules of civil procedure and the longstanding practice of judicial discretion. Under the federal rules, the courts are empowered to manage litigation and to consider equities in their decision-making, yet this bill would strip judges of that authority. And for these reasons, I strongly oppose the bill, and I urge my colleagues to do the same, and with that, I yield back.
Gentleman yields back. Who seeks recognition? Gentlelady from Indiana is recognized.
Thank you, Mr. Chairman. I just wanted to clarify a few things because I don't think this is exactly what the bill is doing, because it doesn't prevent from anything. All it does, it just brings more clarity and transparency to make sure that the processes that happen in the agencies are aligned with Administration Procedures Act. And if there are some new deadlines, there is a transparency that there is public is aware, and if there are some different change in priorities, that we are not shortchanging some other priorities that agencies should be working on. So it's not narrow focus, but have a broader scope of issues that are in front, because there are different things that could be in front of the agency, have more urgency, and then the resources are properly allocated and not guided by judges who shouldn't be really deciding, what policies that agencies should prioritize. So I agree with you. There is a lot of frustration, with agencies not enforcing the laws properly in a lot of areas. And I think this is job of Congress, and we need to do our job, not job of judicial branch to make decisions for us. Otherwise, only large special interest group have ability of input, and we as elected representatives should have an ability to input. As related to mediation's concern, this is actually just given a second opinion to make sure that there is no requirements, for judge to really follow. This is not no mandatory mediation decisions are done. So to have a second opinion, second thoughts with fresh eyes, because sometimes they're very important cases, and it's important to have a second set of eyes. As related to the public notices, I think it says that there should be public notice response, but it doesn't say specific substantive response, but make sure that there is an acknowledgement that the public notice were taken into consideration, and ultimately doesn't require that specific request. So I think this bill, all it does, if we're going to go through these processes that agencies have to address, make sure that they align with the intent of the Congress and also with the policies that in front of that specific agencies and priorities, because it shouldn't be up to judges and judicial branch to create laws for us. An enforcement mechanism, unfortunately, is broken in our institution. We should be the one just saying, okay, if this agency is not enforcing the laws and not meeting deadlines, maybe we shouldn't be funding these programs. Maybe we should be sitting here and reviewing that. That is our job. We are not even passing meaningful budget. Over 90% of spending in our country is not authorized. So we should be the one who are accountable for it, not just to have making deals that are not transparent. So this is the bare minimum, at least brings transparency to make sure if we have bad apples that want to abuse the system, and like a lot of people move around in Washington, D.C. Today they work in agency, tomorrow they work at some lobbying group, a law firm. We need to make sure that deals are not cut, and it happens a lot. And in a lot of interest, it happens a lot. So we need to make sure that there is a way for the public to have an input. So I don't think this bill actually does anything even to address, because this actually, some states were looking at these practices, this shouldn't be allowed at all. So it's not doing that, it's not in addressing that issue. It's not say that, maybe there is a legitimate reasons. I think maybe we should use a lot more of these reasons, for public to be able to have some enforcement, like, our border security, other things. Citizens maybe should also have this option, options on these issues too. So, but ultimately make sure that it's not overstepping the given authority of Congress, and make sure that the judicial system doesn't go beyond what they're prescribed to do to interpret the laws and decision, and not to create new laws, which happening more and more often. So I think it's a separation of power, but also proper representation by Congress. And if Congress is not doing its job, then it's probably should people pay attention to what we are doing, but it shouldn't be resolved within few group of special interest group with big money that have an ability to bring lawsuits and try to make their agenda be prioritized, maybe, hurting some other important issues that any agency should be working on. And I think this is a very good legislation, and I am disappointed that we cannot have transparency supported and public notice on a bipartisan basis. This is a good bill, and I hope my Democrat colleagues will reconsider to support this bill. I yield back.
Gentlelady yields back. Who seeks recognition?
Mr. Chairman, I have an amendment at the desk.
Gentleman from Georgia is recognized. The clerk will report the amendment. Gentleman from California reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 3446, offered by Mr. Johnson of Georgia.
Without objection, the amendment will be considered as read. The gentleman from Georgia is recognized to explain his amendment.
Thank you, Mr. Chairman. My amendment would exempt from the Sunshine Act any consent decree or settlement agreement that prevents or is intended to prevent discrimination based on race, religion, national origin, or any other protected category. As I've said, these are cases where the agency already has a statutory duty to promulgate the rules. Yet, H.R. 3446 would grind the rulemaking process to a halt with nearly unlimited interveners, forced mediation processes, a new notice and comment period for proposed settlements, and other onerous and totally unnecessary requirements. Surely, we must all agree that we cannot delay rules to prevent discrimination based on race, religion, or national origin. It is too crucial to our fabric of our country. Just last week, the Supreme Court upheld a section of the Voting Rights Act that prohibits maps from being drawn to dilute minority voting strength. If states can go back and draw entirely new district maps to ensure that we are not discriminating based on race, I'm sure we can agree to remove barriers and hurdles from settlements that would prevent discrimination based on legally protected categories. I strongly urge my colleagues to support this amendment, and I yield back.
Gentleman yields back. The gentleman from California withdraws his point of order. The gentlelady from Indiana is recognized.
Mr. Chairman, I oppose this amendment because it's really not necessary. It creates not necessary. I mean, our agency shouldn't be discriminated on these issues already, so it just brings a different language that is not really needed for this bill, and this exception is not needed, because I hope that agency do consider and care issues like that, because this is within their duty, and if somebody is discriminated, it's a serious offense. So I don't expect agencies to do it, so I think it just brings issues to the bills that is not really needed to be here, and just bring, application of this policy somehow start separating it from really uniformly properly applied. So I think this is already covered in other type of statutes, and this bill as it is, it's a good legislation to bring transparency, and we don't need any specific carve-outs and reasons to have this amendment. So I would appreciate if my colleagues oppose this amendment.
Gentlelady yields back. Gentleman from New York is recognized.
Thank you, Mr. Chairman. Mr. Chairman, this bill, as I said before, would create a gauntlet of unnecessary, burdensome, and time-consuming procedures that would effectively stifle settlements and consent decrees. This amendment would exempt from the bill consent decrees or settlement agreements concerning a potential rule protecting against discrimination on the basis of race, sex, national origin, or other protected characteristics. Civil rights laws embody one of our nation's most fundamental values, that no one should be treated adversely solely on account of their race, sex, religion, national origin, age, or disability. Consent decrees in particular have been instrumental in enforcing civil rights statutes in a wide variety of cases, ranging from those involving enforcement of voting rights to reform of mental health institutions to addressing law enforcement misconduct. Indeed, they are at the heart of civil rights enforcement. By making it substantially more difficult for agencies to enter into consent decrees or settlement agreements regarding for any regulations that enforce civil rights, this bill effectively undermines Congress's statutory mandates to agencies concerning civil rights. As I said before, I think this is a bad bill. This amendment would make it a somewhat less bad bill, and for this reason, I support the amendment and urge my colleagues to do the same. I yield back.
Gentleman yields back. Who seeks recognition? Question occurs on the amendment from the gentleman from Georgia. Clerk will call the roll. Oh, excuse me. All those in favor, say aye.
Aye.
Those opposed, no. No. Pin the chair, the noes have it.
Mr. Chairman, I request a recorded vote.
Recorded vote being requested by 2 members of the minority. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Isa? Mr. Buck? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Spartz? Ms. Spartz votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Hunt votes no. Mr. Fry? Mr. Fry votes no. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush? Ms. Bush votes aye. Mr. Ivy?
Aye.
Mr. Ivy votes aye. Ms. Ballant?
Aye.
Ms. Ballant votes aye.
Gentleman from Arizona?
Mr. Biggs votes no.
Have all members voted? Clerk will report.
Mr. Chairman, there are 10 ayes and 14 noes.
The amendment is not agreed to. The gentleman from Maryland is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R.
Without
3446.
objection, the amendment will be considered as read. The gentleman from Maryland is recognized to explain his amendment.
Thank you, Mr. Chairman. My amendment would strike,
Point of order reserved by the gentleman from Florida. Go ahead, I'm sorry, Mr. Ivy.
no problem, Mr. Chairman. My amendment would strike the intervention language that's on page 4, lines 2 through 10, for a variety of reasons. First, there's no showing with respect to this language that it's necessary or helpful. In fact, as I think the previous amendment suggested, it could actually be problematic and damaging to litigation and protection of certain rights. I'll go through that in a moment. But just to begin, though, I think it's a solution in search of a problem. The so-called Meese memo has been in place for 37 years now. This was put in place by Mr. Reagan's Attorney General, Edwin Meese, to address some of these issues. My understanding is that it's been followed by administration after administration up until this date. It's been very successful. I know this proposed language has been offered on numerous occasions, but there continues to be no showing, as far as I can tell, that it's necessary or useful. And it continues to have some of the same problems that it's had for the past decade. For example, the ambiguous language. Let me start with the fact that Rule 24, the Federal Rules of Civil Procedure, addresses intervention already and permits a judge to make a determination based on a standard that's been in place for decades now. This would essentially invert that standard and create a rebuttable presumption that virtually any party that sought to intervene in a proceeding would be admitted in doing so, with no impact or no review of what kind of impact that could have on the litigation, or whether it's actually someone who has an interest that isn't actually being represented by the parties that are already in the proceeding. More importantly, it's not clear to me in trying to review this language what the breadth of the scope of it would be. I know it's aimed at consent decrees and settlements, but there's fairly generalized language here that could have an impact beyond that. And I would note that the courts have a process for making amendments to the Federal Rules of Civil Procedure, and they do so when they think it's necessary or beneficial. I'm not aware of the courts having brought forth any kind of proposal as to the need for the change in this language. I don't think the sponsor of this legislation has gotten any kind of suggestion from the judges that it could be necessary or helpful. And more importantly, there's no sense of what the unintended consequences of this language could be. I do think that it would certainly lead to extensive litigation. There's a variety of language in the proposed bill that's vague. For example, unlawfully withholding or unreasonably delaying agency action relating to a regulatory action. There's a lot of language like that that I think would require extensive litigation in trying to determine what the definitions are. And I don't know that that's going to be helpful to the process. I also thought there might be a concern here too. Apparently this is aimed at creating disincentives to settlements and consent decrees, which potentially could lead to the decision by federal agencies to say, okay, fine, even though we would normally pursue a settlement or a consent decree, in part because it saves the expense of litigation and the parties have reached a reasonable accommodation. This creates a strong disincentive against that because actually it creates more extensive litigation in the form of a process of comment periods and the like. And so you might have federal agencies deciding, okay, then let's just litigate it all the way through, which I don't think is beneficial to the courts, to the parties, and I don't think that's the goal of what the Congress has in mind here either. I understand there's some concern about some of these settlements and consent decrees, but I don't share the view that this language is required or beneficial, and I don't think there's been a showing, to be blunt, that it's necessary or even useful. So with that, I would yield back. I ask that all vote in favor of my amendment to strike the intervention language.
Point of order is withdrawn. The gentleman yields back. The gentlelady from Indiana is recognized.
Mr. Chairman, I oppose this amendment, and I want to explain why. Because this is not a typical lawsuits. This is a very specific provisions where citizens are allowed to have an enforcement mechanism. And I said maybe we should look more into that and doing in other parts of the code to more legislation. But if we are going to have this type of input, we need to make sure that is more aligned with Administrative Procedures Act, and stakeholders are at the table in a similar way when we have a public input, when any potentially new changes that can enforce into regulation could make some difference. There should be an input. We have that public input with Administrative Procedures Act, so these cases are more specific, and I think they need to be more aligned. So all it does is it gives an ability, to have an input for the parties that would be affected. So I think it's an important presumption to have and make sure that the courts, considering that, if we're going to move this consideration to the courts, I agree they shouldn't be done at the courts. A lot of these things should be enforced properly by agencies and timely. But if we have to have judicial system involved, we need to make sure that judicial system has the same public input that would be doing in regulatory, our regulatory laws, Administrative Procedures Act, and the Congress within the congressional intent. I think they need to hear more parties, and I think this is extremely important part of this process to bring more transparency and public input in very important cases. So I urge my colleague to reject this amendment. I yield back.
Gentlelady yields back. The gentleman from New York is recognized.
Mr. Chairman, the bill opens the floodgates to industry challenges that would delay the resolution of pending litigation by changing the standard for third-party intervention in underlying litigation. Section 3B of the bill requires courts to presume, subject to rebuttal, that almost any private third party be allowed to intervene in litigation between a public interest group and a federal agency concerning a regulatory action, and would require that such third party be permitted to participate in settlement negotiations between the two litigants. Effectively, this shift in the burden of proof makes it much easier for any party who is not already a party to the case to intervene in a case involving a consent decree or settlement agreement that seeks to compel agency action. Hypothetically, under this bill, if the regulatory action at issue involved the Clean Air Act, any person who breathes air would have the right to intervene in a consent decree or settlement agreement, as would any effective industry entity or anyone else in the United States, subject to a refutable presumption that the parties to the litigation do not adequately represent the third party's interest. If a court were to read Section 3B1 broadly, this provision could open the door to almost anyone intervening in a covered civil action under the bill. By opening opportunities for industry to slow down the process, H.R. 3446 effectively makes it more expensive for agencies to do what Congress has mandated it to do, while imposing greater costs and strains on the judicial system, and in the process waste countless taxpayer dollars in costly procedural delays. The presumption required by H.R. 3446 also upends current law as established by the Federal Rules of Civil Procedure, which place the burden of proof on a third party to show that its interests are not represented by the parties in the case. For these reasons, I support the amendment and urge the committee to adopt it.
Gentleman yields back. Who seeks recognition? Question occurs on the amendment offered by the gentleman from Maryland. All those in favor say aye.
Aye.
All those opposed, no. No. In the opinion of the chair, the noes have it.
Mr. Chairman, I ask for a roll call vote.
Roll call vote being requested. The clerk will call the roll on the amendment from the gentleman from Maryland.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Buck? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Bishop? Ms. Spartz? Ms. Spartz votes no. Mr. Fitzgerald? Mr. Benz? Mr. Benz votes no. Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Hunt votes no. Mr. Fry? Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush? Ms. Bush votes aye. Mr. Ivy?
Aye.
Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye.
Gentleman from South Carolina.
Mr. Fry votes no.
Gentleman from Wisconsin.
Mr. Fitzgerald votes no.
Gentleman from California.
Mr. Liu votes aye.
All members voted. Clerk will report.
Mr. Chairman, there are 11 ayes and 13 noes.
Amendment is not adopted. Gentleman from Colorado is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the point of order being reserved from the gentleman from Florida. Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 3446 offered by Mr. Neguse.
Without objection, the amendment will be considered as read. The gentleman from Colorado is recognized.
I thank the chairman This amendment does something very simple and straightforward. So first, let me just, taking a step back, I understand the gentlelady's reasoning for bringing forward this bill, and while I disagree that the concerns that have been articulated that are sort of the underpinning for this bill are substantiated, at the end of the day, I understand, again, the rationale for her pursuing this. And what I would propose is that given this legislation has largely in the same form been passed by multiple Congresses over the course of the last decade and has not been acted upon by our colleagues in the Senate, that perhaps the sponsor would be open to making a simple amendment that would make the legislation a bit more palpable. And the amendment, just by way of explanation, essentially exempts and accepts from the various requirements within this legislation, which I think are dilatory, but again, understanding that my colleagues have a different view, but essentially would allow for any covered consent decree or covered settlement agreement that prevents or is intended to prevent discrimination against or inflict harm upon veterans from being exempted from this bill. That's it. So we're talking about a very narrow exemption for any kind of settlement or consent decree that would impact veterans. Congress often passes legislation, we do it on a nearly weekly basis, imploring various federal agencies, mandating them to engage in rulemaking on behalf of veterans. It may be rulemaking as it relates to lending practices, for example, rulemaking as it relates to streamlining veterans' benefits in the VA and other various parts of the federal government, ensuring that what I believe to be the dilatory procedures within this bill, the open-ended right of intervention, that those don't apply to veterans' related settlements or consent decrees, I would think is a reasonable step forward. It's not a giant leap. It just simply protects our nation's veterans from ultimately the imposition of the requirements in this bill. So I would, for those reasons, encourage my colleagues to support it, or at least give the amendment some weight, and I'll yield back the balance of my time.
Gentleman yields back. Gentleman withdraws. Gentlelady from Indiana is recognized.
Thank you. I thank you for bringing the amendment, but I'll tell you why I oppose this amendment. I actually am not a huge fan of carve-outs. You know, laws should be applied equally. We have specific protection. If we want to do some specific for veterans, we need to do more, because I truly believe, you know, people that fight for our freedoms really should have a special treatments and special laws specifically for them to make sure that we treat them, you know, with the respect and support that we need. But this is just dealing with the broader issues, and when they start bringing carve-outs, this is not necessary. It creates a lot more problem and confusion. So I prefer personally when we don't separate, because that's what an issue with a lot of legislation. We put this group and then this group, and then it's becoming, and who is not covered, you know, and I think that is becoming a problem. So I think the law should be more uniformly applied, and we have uniform procedures, and we should be doing it within this bill. So I don't think this is exceptions very much needed, you know, and I wanted to just explain that, you know, this bill actually is, all it does, it wants to bring transparency and public input. And that transparency actually and public input maybe would address some of the concerns if people truly believe that it could somehow be inflicting harm on veterans, because I don't think public would like that. And that public input and ability to have that, actually it's a good thing that you don't have deal making between some agency and groups that maybe doesn't care about veterans. That's why I think this is a good language in this bill that has an ability to address this concern, but not just for veterans, but actually all of the concerns that potentially could be done, you know, in the processes that really shouldn't be even happening. I mean, I agree with you. Our agencies should be meeting these deadlines, and it needs to be a conversation why they are not doing it, and we continue funding these agencies. You know, I think we should be doing enforcement of the laws, and this is unfortunate that we even have to go through these processes, and then they need to go to the court. So maybe hopefully our agencies will start to do a better job in understanding, you know, that they have to enforce the laws, and Congress meets this deadline, but we have to look, you know, because it means that things are already not done timely. So we need to make sure that the new facts could be brought up, new inputs could be brought up if unfortunately things hasn't been done within the deadlines, that we set as a Congress. And there is a public input, and I think that public input would address your concern, that you have in this amendment. So I don't think we need to start doing all this carve-outs, brings confusion in applications of law, and I urge members of the committee to reject this amendment.
Gentlelady yields back. I think we have several. Ms. Ross, and then I'll come to Ms. McBath.
Thank you, Mr. Chairman. I don't support the underlying bill, but I do see this amendment as a huge improvement to the underlying bill and appreciate my colleague for introducing it. We have veterans, particularly in North Carolina, who have suffered from toxic chemical exposure. This Congress just recently finally is giving them some relief under the PACT Act. There are settlements that are being considered right now. Our veterans deserve to have swift and sure justice. And if they can get a favorable settlement without all of the mumbo jumbo that's going to go on in this bill, it is our duty to provide them that swift and sure relief. And I encourage all my colleagues on both sides of the aisle, for the sake of our veterans communities, particularly those who have suffered at the hands of our government, to give them the compensation and the surety they deserve. And I yield back.
Gentlelady yields back. Gentleman from New Jersey is recognized.
I wasn't going to speak, but I'm just going to say a few words here. The purpose of this bill and the accomplishment of the bill would actually be to clarify those types of issues, not to hurt veterans, but to help veterans and to help other members of the public and other groups. There's no question that the way we can currently construct what we do can be harmful to different groups and not necessarily achieve the intended goal. And I don't mean to be, and I'm hopefully not being, mean-spirited, but these carve-outs are more political in nature than they are governmental or judicial or legislative. They're ways, and quite frankly, and let me be the one to say it, that, in future you can go forward and say, oh, they voted against veterans. They didn't want to help the veterans. And that's not the purpose here. This would do more help to veterans than harm. It would do more help to everybody than harm. There's too much red tape, and hopefully this would move things through faster. And the very point that was made, how long it's taken, how long everything takes to help good people, is in part due to the current system that we have now. I yield back my time.
Gentleman yields back. Gentlelady from Georgia is recognized.
Thank you, Mr. Chairman. And I urge my colleagues to support this amendment. And in doing so, we talk about, carve-outs. I don't believe that what my colleague from Colorado is creating is a sense of a carve-out more than anything than protections for our veterans and actually clarifying those protections, which I think is extremely important. So I do urge my colleagues to support this amendment. Let's stop talking about this as carve-outs. These are things, these are supports, a support system that our veterans most assuredly need. As my colleague from North Carolina had stated, let's make sure that we're doing right by those that have given and sacrificed to this country. And with that, I'd like to yield the balance of my time to my colleague, Mr. Neguse.
I thank the gentlelady from Georgia for her support, and certainly my colleague from North Carolina as well, and would echo their sentiments. Look, this is a substantive amendment. I've been on the, I understand the concerns articulated by the gentlewoman from Indiana, and I think she's intellectually consistent in terms of the argument that she's making against the amendment. I understand that her belief around carve-outs. I think that there is a need for special dispensation here because we have a special and sacred vow and commitment to our veterans, and so to me it makes sense that we would have this carve-out in that frame, but again, I understand the gentlewoman's objections to that. But I disagree fundamentally with my colleague from New Jersey. This isn't a messaging amendment. I've served on this committee for several years, longer than the gentleman from New Jersey has. I'm not in the business, at least I think many of my colleagues on the other side will agree, in making messaging amendments. It's a practical amendment that actually would have a real impact, I think, to benefit our country's veterans. And just to give you an example, essentially what this would do, again, we pass on suspension bills every week, good bills, bipartisan from both sides of the aisle, to try to help our nation's veterans. For example, imposing on an agency a requirement to engage in a rulemaking that relates to the for-profit predatory practices that are often targeted against our nation's veterans. This bill, essentially, without this carve-out, would enable that potential rulemaking to the extent the agency is delayed and a private party, a veteran or a veterans organization, challenges the agency's lack or inability of desire to move forward on that rulemaking. It would ultimately stifle and slow down the ability for that party to negotiate a settlement or a consent decree with the agency, which ultimately would inure to the benefit of our nation's veterans. So I get it. I mean, I understand if again, folks don't want to do a special carve-out. That is an argument that one can make, but I disagree, again, fundamentally with my colleague from New Jersey to the extent that he argues that somehow the existing language would speed up the settlement process or a consent decree by a federal agency as it relates to harm against veterans. It's just not supported by the text of the bill. This amendment would certainly help in that regard, and frankly, I'd have to give some real pause as to I may very well even support the bill if this amendment were adopted or at least considered in good faith, but it seems like that's not in the cards. So with that, I'll yield back the balance of my time.
Gentleman yields back. Gentleman from Virginia, Mr. Klein, is recognized.
Thank you, Mr. Chairman. I yield to the gentlelady from Indiana.
Well, and thank you for bringing them in, but I want to give you a different proposal because, I'm not going to question intent. We're doing a lot of politics here, unfortunately, but if we want to really, enforce the laws that what agencies are doing, we actually should do it as part of our appropriation process. Maybe we should look in our VA funding. There are a lot of problems that VA is not addressing, and some other agencies dealing with veterans. And if they're not doing job and not meeting deadlines, we have an ultimate strength, power of the purse. We actually can make a difference. And the appropriation process that is going to be happening this year, it's our opportunity of Congress to say, okay, let's put oversight on all of the deadlines that agencies haven't met that we, Congress, prescribe. And look what finding. Why are we finding, continue fighting the agencies that are not doing its job? That is how we can make a difference if we really want to protect veterans, which we need to do. That is the power we have. It should be done by us, Congress. It is our job. It's not even job of judicial system to deal with all of this issue. That should be last resort, period. And it means that they're dealing with that if we're not doing jobs. So I want to offer you an opportunity maybe to have this conversation as part of appropriation process where we can start defunding some of these agencies that are not doing the job prescribed by Congress, because that will be a meaningful way to help these people, because that's only care. We can write a lot of letters, we can like a lot of different laws that are not going to go anywhere, but when we don't give them the money, that's when they start listening to us. And unfortunately, our executive branch hasn't been serving the American people. And we should be able, as a legislative branch and policymaking, be independently of the party, have a proper oversight of the branch. And we used to do much better job with that. And I'm not saying because we have Democrat in the White House. It's been bad under Republicans too. And we're not doing a good job. Our function is to set policy. Their function is enforce policies, and if they are not enforcing, we shouldn't even continue them the money. But we not even have a very serious conversation about budgeting and authorizing our spending. We're not doing anything here. I'm not sure even what we're doing here. In a lot of ways, it makes me wonder what the Congress is set up to do. We set up authorization process, and it's not even going through any committees. We waive authorization of spending, and appropriation committee shouldn't be the powerhouse of few people, even though my colleague that yielded me time is on the appropriation committee, so he might disagree with me. But it shouldn't be the few people that make decisions for all of us. We should be authorizing in the committee of jurisdiction. We have a committee doing that. And if that committee is not doing the job, we should have this question. And I'm not saying just because it's a political. No, I think this is the job of Congress. And I think it should be done on a bipartisan basis. That's where this conversation should be. Are we doing a good job for veterans or not, because I don't think we are. And I have a lot of veterans in my district complaining what's happening right now and how, I mean, it's better than before, but we have lots of employees on these agencies. And there is no excuse that they're not doing this law. So I'm open when we look at that, you know, in our fund and stuff to have these discussions, because I actually would be very supportive of that. But I just don't think this is a place to start doing that. And I think the bill like it is, bringing transparency, is actually a good thing. You know, and if there are some little things that we need to adjust in Rules Committee, I'll be open-minded to do with some legality. But I think, you know, as a substance, it's just bill just bring transparency to the process, which really should exist. And honestly, the process shouldn't even exist, okay? If we would be doing our job, we would not have to be even doing these processes. And people would not have to spend money, energy, and effort to enforce the laws for us, because we should be the one that check the laws enforcement. And I yield back.
Gentlelady yields back. Gentleman from Virginia.
I thank the gentlelady. My heart leapt when she said reauthorization of DOJ, and with that, I yield back.
Gentleman yields back. The gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I join in the gentleman from Colorado's views with respect to an openness to trying to work through this, but I do think there's sort of a fundamental difference. I don't agree with the overall policy of the bill either, but the issue here is whether, within this bill as I read it, it's going to extend litigation from a time standpoint, potentially for years. In fact, what it does is it permits strategic elongation of litigation. So people can find, because you don't have deadlines in here for when these motions can be done. So under Rule 24, there are deadlines set. If you want to try and intervene in the case, not only do you have to do it within a short period of time, you have to do it early. And the reason you have to do it early is so that the parties in the litigation know who they're going up against. They can all participate in discovery. But from a judge's standpoint, more importantly, the judge can say, okay, discovery's over now, we're going to move to the next phase. The judge can manage the schedule of the trial, of the whole proceeding, and move it forward. In fact, that's one of the primary goals of district court judges. In fact, they judge themselves on their timelines. They keep track of how long they've had cases, how long it's taken them to move it forward. If they're taking too long, their chief judge says, you need to pick it up. This changes that, because it takes that power essentially out of the district court judge's hands and says people can intervene almost whenever they feel like it. And they can wait till late in the process. They can wait till almost the end of the process. Consent decree and settlements typically would be the end of the process when things are about to be over, and in this instance, the veteran's about to get the benefits that they sued for. But that could be taken away because this process adds additional time. People would have to, there would have to be an announcement that a settlement or consent decree is pending, and then there'd be, within 60 days of it being made clear to the court. But there's no deadlines after that. So it could take who knows how long. And that's why what I was saying earlier, this could create an incentive to just litigate it all the way through, because you don't know when it's going to stop. So I take the gentlelady's point, and my assumption is this is aimed at some of the other things we've had hearings about, whether the FDA, EPA, some of the administrative agencies that my Republican colleagues want to push back on. But individuals could get hurt in this process, and they're not part of the big procedures or policies or anything. These are people who have individual claims that they want to have addressed in a court, potentially to get money or benefits they deserve. And I don't think anybody here questions that veterans ought to get the benefits that they've earned. And we shouldn't elongate or delay any process that enables them to do that. So I think this amendment, I'd strongly encourage the Republicans to consider it, because that's what it would do. I mean, I think, again, I disagree with the overall premise of the bill. I get the strategy with respect to some of the regulatory agencies and some other aspects of it, but because you don't carve that out and focus specifically on that with this language, it could be any, it could be any settlement that's connected with the APA, the Administrative Procedures Act, and that's a problem. So I would urge not only my colleagues, but the Republican colleagues as well, to adopt this amendment and protect veterans at a minimum from delayed litigation and delay in getting the benefits they deserve.
Gentleman yields back. Who seeks recognition? Gentleman from California.
Thank you, Mr. Chair. I rise in support of this amendment offered by the gentleman from Colorado, and I just want to give you a real-life example. As a veteran myself, I worked on the West LA VA, which is the nation's largest VA hospital, and before I went to Congress, it was largely dysfunctional. In fact, it was so dysfunctional that veterans and public interest groups sued the VA. As a result of a settlement, it has now created a master plan for a new master plan for VA campus. It's improved veterans care. It has improved delivery of veteran services. And next week, I'm going to go to a groundbreaking for new buildings to house homeless veterans. If this amendment is not adopted and this law was in effect, I would not be going to that groundbreaking. It'd be years and years away. And so this is just a very reasonable amendment. It would allow veterans to sue the VA, get settlements, and not have those settlements be delayed for years and years and years. So I urge adoption of this settlement. I yield back.
Gentleman yields back. Question occurs on the adoption of the amendment from the gentleman from Colorado. All those in favor say aye.
Aye.
Those opposed, nay. No. And pin the chairs, the noes have it.
Roll call vote, please.
Gentleman requests a recorded vote. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Isa? Mr. Buck? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? No. Mr. Biggs votes no. Mr. McClintock? No. Mr. McClintock votes no. Mr. Tiffany?
No.
Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Bishop? Ms. Sparts? Ms. Sparts votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Bentz? Mr. Bentz votes no. Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Hunt votes yes. Mr. Fry? Mr. Fry votes no. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Schiff? Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy?
Aye.
Mr. Ivy votes aye. Ms. Ballant? Aye. Ms. Ballant votes aye. Mr. Moran, you're not recorded. Mr. Moran votes no.
Gentleman.
Mr. Johnson of Louisiana votes no.
All members voted. Clerk will report.
Mr. Chairman, there are 9 ayes and 15 noes.
The amendment is not adopted, is not approved, I should say. Questions on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye.
Sure?
All those opposed say no.
No.
Opinion of the chairs, the ayes have it. And the amendment in the nature of substitute is adopted. The reporting quorum being present, the question is on favorably reporting the bill as amendment. All those in favor say aye. Aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered to be reported favorably to the
Mr.
House.
Chairman?
Roll call being requested. The clerk will call the roll on the final passage.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Isa? Mr. Buck? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Aye. Mr. McClintock votes aye. Mr. Tiffany?
Aye.
Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Sparts? Ms. Sparts votes aye. Mr. Fitzgerald. Mr. Fitzgerald votes aye. Mr. Benz. Mr. Benz votes yes. Mr. Klein. Mr. Klein votes aye. Mr. Gooden. Mr. Van Drew. Mr. Nels. Mr. Moore. Mr. Moore votes yes. Mr. Kiley. Mr. Kiley votes aye. Ms. Hageman. Mr. Moran. Mr. Moran votes aye. Ms. Lee. Mr. Hunt. Mr. Hunt votes aye. Mr. Fry. Mr. Fry votes aye. Mr. Nadler.
No.
Mr. Nadler votes no. Ms. Lofgren. Ms. Jackson Lee. Mr. Cohen. Mr. Johnson of Georgia. Mr. Schiff. Mr. Schiff votes no. Mr. Spalwell. Mr. Liu. Mr. Liu votes no. Ms. Jayapal. Ms. Jayapal votes no. Mr. Correa. Ms. Scanlon. Ms. Scanlon votes no. Mr. Neguse. Mr. Neguse votes no. Ms. McBath. Ms. Dean. Ms. Dean votes no. Ms. Escobar. Ms. Ross. Ms. Ross votes no. Ms. Bush. Mr. Ivy.
No.
Mr. Ivy votes no. Ms. Ballant. Ms. Ballant votes no.
Gentleman from Louisiana.
Mr. Johnson of Louisiana votes yes.
Gentleman from Texas. Yeah. Clerk will report.
Mr. Chairman, there are 14 ayes and 10 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and the staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 1525, the Fair Act of 2023, for purpose of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 1525 to restore the integrity.
Without objection, the bill will be considered as read and open for amendment at any point. I recognize myself for an opening statement. H.R. 1525, the Fifth Amendment Integrity Restoration Act of 2023, also known as the FAIR Act, will reform civil asset forfeiture law in ways that protect innocent people from having their property taken unjustly. Current federal law allows agencies to seize private property under certain circumstances, such as when property has been or likely will be used in the commission of a crime. For example, law enforcement officers may seize a person's car, cash, or other material possessions that authorities believe may sooner be used for criminal activity, regardless of whether there is an actual relationship between the property and the potential criminal activity. This practice can harm innocent owners when property is taken and held without any due process to justify the taking. In addition, law enforcement agencies across the United States sometimes use proceeds from civil asset forfeitures to fund their own operations. This can create a perverse incentive to seize and sell private property as potentially innocent citizens, to increase agency revenues. Despite some states' efforts to protect property rights, a system of equitable sharing, where federal law enforcers execute seizures using information shared with them by state law enforcement, means forfeiture can proceed under less protective federal standards. The result is a system that unjustly infringes on the liberties of innocent American citizens. As one commentator has observed, civil asset forfeiture, quote, has metastasized to serve ends far beyond its reach. The reforms in the FAIR Act have bipartisan support. They will eliminate administrative forfeiture, increase the burden of proof on government to show that property is related to criminal activity, and shorten the time for seized assets to be returned to their rightful owners. Further, none of these reforms will keep government from protecting the public effectively through legitimate law enforcement tactics. I urge my colleagues to support H.R. 1525. The FAIR Act will bolster integrity in law enforcement and protect the property rights of the American people. I now recognize the gentleman from New York, the ranking member, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, I strongly support H.R. 1525, the Fifth Amendment Integrity Restoration Act, or the FAIR Act of 2023. As currently written, our federal civil asset forfeitures laws lack significant Fifth Amendment due process protections and create a set of perverse incentives for federal agencies to pursue civil forfeiture in cases where it is unwarranted. First, federal civil asset forfeiture laws do not require the government to prove before a court that the individual's property is to be seized committed a crime beyond a reasonable doubt. Indeed, federal agencies are empowered under an administrative process to decide forfeiture cases without any judicial oversight. Additionally, the value of the forfeited property is often less than the cost of procuring legal counsel, which is a necessity given the Kafkaesque nature of federal civil forfeiture proceedings. This is problematic for any individual seeking the return of their property, but it makes it nearly impossible for lower-income people who are particularly harmed by the seizure of money or property to vindicate their rights. This concern is further heightened by a report presented by the Institute for Justice at a hearing the Subcommittee on the Constitution held last week, which found evidence that the burdens of civil asset forfeiture laws fall disproportionately upon working people from communities of color, who statistically are likely to have even fewer financial resources upon which to draw. These already problematic features of the federal civil asset forfeiture process are further compounded by the equitable sharing program between federal and state law enforcement. This program allows state authorities, even in states that have eliminated or reformed their own laws, to receive a percentage of forfeited funds referred to the federal government for seizure. Thus, the low standard of proof the government must meet under federal law, combined with the lack of due process protections and the structure for the receipt of forfeited funds, creates perverse incentives for federal and state law enforcement agencies to seize money or property from among the most vulnerable people in our communities to supplement their budgets. The FAIR Act would begin to address these problems. The bill would eliminate the administrative process so that only an Article III judge could order a forfeiture. It would heighten the legal standard for forfeiture to require clear and convincing evidence. It would provide access to counsel for indigent civil defendants seeking the return of their property. It would abolish the equitable sharing program between federal and state law enforcement agencies, and it would require that federal forfeiture funds be sent to the U.S. Treasury's general fund rather than be deposited into funds that may be used for law enforcement purposes, among other reforms. These reforms enjoy bipartisan support and are supported by a broad coalition of advocacy organizations, including the Leadership Conference on Civil and Human Rights, the NAACP, the NAACP Legal Defense Fund, ACLU, the Institute for Justice, Americans for Prosperity, and the R Street Institute. I would also like to thank Representatives Tim Walberg and Jamie Raskin for introducing the bill, and Chairman Jordan for bringing it up for consideration today. I urge my colleagues to support this important legislation, and I yield back the balance of my time.
Gentleman yields back. Without objection, all of their opening statements will be included in the record. Chairman, I recognize himself for the purpose of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 1525.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of amendment. The chair recognizes himself to explain the amendment. This amendment makes several minor tweaks and technical alterations to improve the bill. It is not intended in any way to alter the important purpose of this legislation. I urge support of the amendment and yield back. Who seeks recognition? Question. Gentlelady from Pennsylvania.
I move to strike the last word.
Gentlelady is recognized.
Thank you. Our federal civil forfeiture system is in need of reform, and I'm really heartened by the bipartisan support that this bill has. The FAIR Act would address serious due process concerns raised by our civil asset forfeiture laws and the perverse financial incentives they have created. So the reforms will end the use of administrative forfeitures so that federal courts must consider forfeiture claims. It will adjust the burdens of proof to make a civil forfeiture and the defenses to forfeiture increased in fairness to those who are impacted. It'll provide access to counsel for those seeking the return of their property and require federal forfeiture funds to be sent to the U.S. Treasury, thereby ending some of the perverse financial incentives that the current process has. Before I mentioned when we had a hearing on this last week, before coming to Congress, my work included collaborating with legal aid and civil rights agencies to provide representation to low-income Philadelphians who'd become victimized by abuses to Pennsylvania's civil forfeiture statute. Over the course of many cases, we were able to change the burden of proof in Pennsylvania and get some of the same types of reforms that we're addressing here by statute for the federal law. Prior to those reforms, we saw in many cases elderly homeowners who had never been charged with any crimes have their homes, their cars, and their worldly goods seized without any suggestion that they had ever participated in misconduct. And often the complexity of that legal process, the harsh standards of proof, and the cost of asserting their basic rights cause these low-income individuals to be unable to raise defenses to the forfeiture process. In many cases, as the ranking member mentioned, the cost of obtaining representation far exceeded the value of the property that was to be seized, and innocent people were left financially devastated and even often homeless without any recourse. So fundamental fairness requires that Congress ensure that people are protected from wrongful seizure of their property, and this bill creates some essential guardrails against many of the abuses of civil forfeitures laws that have raised real constitutional concerns for all of us. As it stands, the federal statute encourages state and local agencies to partner with federal law enforcement to seize assets. This will end that. And the FAIR Act overall addresses many of the persistent abuses of civil asset forfeiture. I think there's still more we can do, but I would urge all of my colleagues to support this bipartisan bill. I yield back.
Gentlelady yields back. The gentleman from Virginia is recognized.
Thank you, Mr. Chairman. I want to voice my support in support for this bill. I associate myself with the comments of the gentlelady from Pennsylvania. I think this bill is long overdue. Our federal standards for civil forfeiture invite abuse and can result in unjust outcomes for innocent parties. Currently, recovering property that's been unjustly seized is difficult, and agencies are sometimes able to hold on to that private property. And that's why federal reform is so necessary to restore the original intent of the law, remove incentives for agencies to unjustly seize property, and better protect the property of innocent citizens. I urge my colleagues to support the bill. I yield back.
Gentleman yields back. Who seeks recognition? Question on the adoption of the amendment in the nature of a substitute. This will be followed by immediately by a vote on reporting the bill. All those in favor say aye. Aye.
Aye.
Those opposed, no. In the chair, the ayes have it. And the amendment in the nature of substitute is adopted. The reporting quorum being present, the question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. In the the chair, the ayes have it, and the bill is.
I'd like to request roll call.
Roll call being requested. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Spartz? Ms. Spartz votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Bentz votes yes. Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes aye. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes aye. Mr. Moran? Mr. Moran votes aye. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Schiff? Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Ms. Bush votes aye. Mr. Ivy? Ms. Ballant? Ms. Ballant votes aye. Mr. Tiffany?
Aye.
Mr. Tiffany votes aye.
All members voted. Clerk will report.
Mr. Chairman, there are 26 ayes and 0 noes.
The ayes have it, And the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in nature of substitute incorporating all adopted amendments, and staff is authorized to make technical conforming changes. It's a new day for the Judiciary Committee, unanimous. This concludes the committee's business for the meeting, and the meeting is adjourned.